really happy to be able to, my name is Trudeau Lemons, but I think I know most of the people in the room. And also for the people who are listening via Zoom. Very happy, particularly happy to introduce YY Brendan Chen today as a speaker. YY studied his SJD several years ago now already here at our university. And he's now a professor at the University of Ottawa's Faculty of Law, the Common Law section. He is his particular expertise is in health law, constitutional law, and immigration and refugee law, the latter which will be the topic of his presentation. He's trained as a lawyer and social worker. His research leverages social legal studies, action research, and community engagement to critically examine health inequities facing non-citizens and racialized minorities. His published work has touched on such topics as migrant healthcare, the right to health, social determinants of health, medical tourism, and HIV/AIDS. And after YY's presentation, we are very pleased to have Kathleen Hammond, a colleague from downtown, who is an assistant professor at the Lincoln Alexander School of Law of the Toronto Metropolitan University. Prior to joining Lincoln Law, she was a postdoctoral fellow with the research group on health law at McGill University's Faculty of Law, and a visiting fellow with the Petrie Fund Center for Health Law and Policy at Harvard. She holds a JD and BCL from McGill University, which I agree is a good university. She completed an MPhil in multidisciplinary gender studies and a PhD in legal sociology at the University of Cambridge, where she was a Gates Cambridge scholar. And so she will comment after YY. After her commentary, we will open it up for questions. I have some questions that the students already sent me, and then we'll open the questions for YY.
Thank you, Trudeau, for inviting me back to your team. And good afternoon, everyone. It's a real pleasure to be back here to see some dear old friends and also make new connections. So my presentation today is based on a short commentary that I wrote earlier this year for the International Journal of Gynecology and Obstetrics that was titled International Migrants' Right to Sexual and Reproductive Health Care. For the most part, the way that my presentation will unfold today will track the structure of the paper. So first of all, I will set the stage by describing how migrants, particularly migrant women and children, often face significant barriers in host communities when trying to access sexual and reproductive health-related information, goods, and services. Then I will give an overview of migrants' right to sexual and reproductive health care guaranteed under international human rights law and the corresponding duty that is placed on receiving countries. Finally, I will conclude by offering a few thoughts on the domestic legal implication of these state duties found in international law. But before I dive into the substance of my talk today, let me clarify my terminology. As you just heard, for the purpose of my talk today, I used the word migrants to describe the population that I'm examining. And by doing so, my intention is to define the term migrants relatively broadly. It will capture everyone that moves across international borders for the purpose of settling in another country, be it temporarily or permanent. And so that means, contrary to some usage of this term, I actually includes refugees and asylum seekers in what I will call migrants for the purpose of this talk. Although it is not my intention to minimize the genuine difference that may exist in the motivations behind why these two groups of people moved in the first place. So, empirical studies after studies have shown that migrants encounter threats to their sexual and reproductive health throughout the international migration process, right? From pre-departure to transit and to even after they have arrived and settled in receiving countries. And this is particularly so for migrants who experience intersecting marginalization. So that will include women, children, people living with disabilities, and members of the LGBTQ2+ community, right, who face elevated risk of gender-based violence, sexual harassment, coercion, and abuse. Studies also show that due to intersecting effects of xenophobia, racism, sexism, poverty, social isolation, and so forth, migrants tend to have sexual and reproductive health outcomes when compared to non-migrants. And I gave some examples in the paper, but I'm not going to dive into that in detail today. All that's to say that despite this elevated risk of harm to their sexual and reproductive health, migrants often face significant barriers when searching for necessary healthcare information, goods, and services, and leaving many of their sexual and reproductive health needs unattended. One of the causes of these access barriers is the fact that migrants, I was told I need to admit people on Zoom. Sorry about that. Migrants, right, especially those with precarious legal statuses, are frequently excluded from publicly funded healthcare in receiving countries. Or, sometimes they will see their entitlement to publicly funded healthcare limited to emergency care settings. Or sometimes, in lieu of providing publicly financed healthcare, receiving countries actually require certain migrants to purchase private health insurance. The coverage under these private insurance plans may fall short for a number of reasons. And they may not cover some sexual and reproductive health goods or services. For example, they may actually place a waiting period before coverage for the cost related to pregnancy kicks in. Or they may require patients to cover the healthcare cost beforehand and seek reimbursement later, something that not everyone can afford to do. And, without some form of health insurance, be it public or private, to defray at least part of their healthcare costs, usually sexual and reproductive health goods and services are simply too prohibitively expensive for most migrants. Now, even when the cost is not really a concern, migrants may still encounter challenges accessing sexual and reproductive health services owing to language barriers, intersecting forms of discrimination, unfamiliarity with what's available to them in the receiving countries, and social and or geographical isolation, to name but a few. And so in the paper, I actually used 3 vignettes to concretize how some of these access barriers play out in real life. Now, I take it that it's obvious when I was constructing the vignettes, the stories I'm telling are based in lower and middle income countries. But it's not my intention to mean that the barriers to to accessing sexual and reproductive health care that I'm talking about today only happens in those contexts. And without a doubt, many of the same barriers exist in higher income countries as well. So for instance, in one of the vignettes, I described a situation where a migrant worker was having difficulty seeking healthcare, right? Because she lived with her employer, and every time that she needs to leave the house, she actually needs to get permission from her employer, right? Including going to see a doctor. And she feared that if her employer found out that she was accessing support and services for sexual and reproductive health, this may jeopardize her job. It is well documented that similar concerns exist here in Canada as well. For example, right, many seasonal agricultural workers work long hours, typically for 6 or 7 days a week, and they live in housing provided by their employer. This meant that they have limited time or privacy from their employers to seek necessary health care, including those of a sexual reproductive nature. And the problem is compounded by the fact that employers are known to terminate the contracts of these migrant workers and send them home early when they learn that the migrant workers may be ill or pregnant, right? Something that was called medical repatriation. Now, this prospect of medical repatriation serves as a strong deterrent to migrants' healthcare access. Okay, so hopefully that sets the stage for our exploration of international law today. At this time, before turning to international human rights law and how it responds to these impediments to healthcare, with your indulgence, I actually want to take us on a bit of a tangent. And I'd like to talk to you about the case of Toussaint in Canada. I trust that the story of Nell Toussaint may be a familiar one to at least some of you. So Nell came to Canada from the island country of Grenada in 1999 on a visitor visa. While she was here, she managed to secure a job, and so she decided to stay after her visa had expired. So for nearly a decade, she worked to support herself, but unfortunately, in about 2006, Nell began to experience a series of health challenges that prevented her from working. Over the next few years, she would be diagnosed with a host of illnesses, right, including chronic fatigue, uterine fibroids that was causing her pain, pulmonary embolism, and uncontrolled diabetes and associated problems with her kidneys, eyes, nervous systems, among others. But as an uninsured person, to rely on charitable care that she was fortunately enough to receive from time to time. But for the most part, she would simply delay seeking treatment that she required for her illnesses because she just could not afford the care. By 2009, Nell's health had deteriorated to the point where a doctor warned if her conditions were not cared for in a timely fashion, it might lead to life-threatening consequences. And so in that year, with the help of her lawyer, Nell applied for healthcare coverage under the Interfederal Health Program, or the IFHP, which, as you know, is a federally administered program that mainly pays for the healthcare costs of refugees and asylum seekers in this country. But because Nell was not an asylum seeker or refugee, her IFHP application was refused. Now, in the ensuing years, many of the warnings made by Nail's doctors about her health back in 2009 would actually come to pass. So as you can probably gather by looking at the picture on the slide, as a result of Nail's health conditions, she is now partially blind. She had one of her legs amputated above the knee. And she suffered from kidney failures, which to this day required her to go under dialysis several times a week. And she has a hard time speaking due to a stroke that she had suffered, as well as an anostic brain injury. Yet, when Nail challenged her IFHP denial in the federal court and the Federal Court of Appeal, she found no success. Among other things, Nail had argued that her exclusion from the IFHP unjustifiably infringed her rights to life and security of the person, protected under Section 7 of the Canadian Charter of Rights and Freedoms. At the federal court, Justice Zing, looking to all the medical evidence before him, accepted that the government had indeed deprived Nail of her rights to life and security of the person. However, he ruled that such deprivation was not contrary to principles of fundamental justice. And he opined, and I'm just going to quote, he said, "I see nothing arbitrary in denying financial coverage for healthcare to persons who have chosen to enter and remain in Canada illegally. To grant such coverage to those persons would make Canada a healthcare safe haven for all who require healthcare and healthcare services. There's nothing fundamentally unjust in refusing to create such a situation." On appeal, the Federal Court of Appeal actually doubled down on Justice Zing's ruling. In fact, it held that there was no government deprivation at all in this case. According to the Federal Court of Appeal, any injury that Nail had suffered in relation to her life and bodily security was not caused by the government, but by her own choice, right, her own conduct of remaining in Canada without any legal status. Now, as some of you know, I have very strong opinions about what the court said in this case, and I can likely go on forever just critiquing what the court's ruling said. However, in the interest of time, I'm not going to do that, but I'm simply going to draw your attention to one more aspect of the federal court's ruling. So besides charter arguments, Nail and her legal team actually argued before the federal court that her exclusion from the IFHP contravened Canada's legal obligations under international law. Specifically, they pointed to a number of international treaties that Canada had signed that promises everyone's right to health. In its decision, the federal court dismissed this argument relatively swiftly, right? Literally in 3 paragraphs. The court emphasized that, well, Canada has a dualist approach to the reception of international law. So that means international treaties do not form part of the Canadian law unless they have been expressly implemented by the legislature. And since no statutes have been passed in Canada to implement international human rights that guarantee the right to health, well, Nail's international law argument in this case must fail. Now, I don't think that the court's decision in this case, in this respect, is all that surprising. But some of the remarks that Justice Zing made on this issue in Commentator still strikes me as jarring. In particular, he observed the following. He said, while there is an international right to health, defining the content of such a right is a formidable challenge. Right? Even more contentious at international law is whether a right to health places positive obligations on a state to provide certain health services to non-citizens present in a state's territory with or without status. As you can imagine, I disagree with the court's statement here. And in some ways, the paper that I'm presenting today is meant as a response to this notion that the guarantee of the right to health under international law may not impose a corresponding duty on governments toward migrants, right, that are present in their jurisdiction. As I want to demonstrate to you now, international human rights treaties, as they have been interpreted by the relevant treaty bodies today, clearly protects migrants' right to health, right, including sexual and reproductive health. And they place a duty on receiving countries in to respect, to protect, and to fulfill this right. So that's essentially my thesis. And so I'm going to kind of lay that out to make my argument. And the obvious starting point of any international legal protection of, or any discussion about international protection of the right to health, I think would be Article 12 of the International Covenant on Economic, Social, and Cultural Rights, right, the ICESCR. I trust that this is familiar to many of you. I'm just going to quickly mention that paragraph 1 of the article reads, the states parties to the present covenant recognize the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. And you see that paragraph 2 of the same article goes on to stipulate a number of concrete steps that the state parties must take in order to fulfill this right, including measures aiming at reducing the stillbirth rate and infant mortality, and securing the healthy development of the child. And state parties are also required to take steps toward the prevention, treatment, and control of epidemic, endemic, occupational, and other diseases, as well as the creation of conditions to ensure everyone's access to mental services and mental attention in the event of sickness. On a plain reading of just this article, it would seem to suggest that the promise of the right to health encompassed a right to timely and appropriate sexual and reproductive health care. And this is in fact confirmed by the UN Committee on Economic, Social, and Cultural Rights in General Comment number 14. And as you know, General Comment number 14 represents one of the most comprehensive and authoritative elaboration of the right to health under international law today. In regard to sexual and reproductive health, the General Comment notes that the right to health has both a negative and a positive aspect. The negative aspect entails the right to sexual and reproductive freedom, which requires governments to ensure people's control over their own health and their own body. The positive aspect, on the other hand, entitles everyone to a range of sexual and reproductive health-related information, goods, and services, including but not limited to sexual health education, family planning, pre- and postnatal care, emergency obstetric services, and prevention and treatment of sexually transmitted infections and HIV. Whereas international law's guarantee of the right to health in general is subject to progressive realization and commensurate with the resources available to each state party. Assurance of affordable and high quality reproductive, maternal, and child health care is considered a core obligation, right, that all government must achieve in order to discharge their minimum duty in relation to the right to health. Right? So it's not subject to the progressive realization proviso. Now, again, it's not my intention here to thoroughly flesh out the content of the right to sexual and reproductive health care under international law. Rather, the point I really want to make is that this right is guaranteed to migrants and non-migrants alike. So if you look at the same general comment, right? General comment number 14, the Committee on Economic, Social, and Cultural Rights observed that states are under an obligation to refrain from denying or limiting equal access for all persons, including detainees, minorities, asylum seekers, and illegal immigrants, right, to preventive, curative, and palliative health services. Now, admittedly, it is somewhat unfortunate that the committee comment here uses a double negative, but you know, essentially it's calling on the state to refrain from denying migrants access to a full range of healthcare services. Nevertheless, I think it's quite clear that according to the committee, international law's guarantee of the right to health certainly extends to migrants, including those without any legal status. In fact, in another general comment relating to the guarantee of the right to social security, namely general comment number 19, the same committee notes unequivocally that refugees, stateless persons, and asylum seekers, and other disadvantaged and marginalized individuals and groups should enjoy equal treatment in access to non-contributory social security schemes, including reasonable access to health care. Other human rights treaty bodies have made similar observations about migrants' right to health care, as well as receiving countries' corresponding duties. As a case in point, concerning women's right to health, the Committee on the Elimination of All Forms of Discrimination Against Women, CEDAW, has directed states parties to pay special attention to the health needs and rights of women belonging to vulnerable and disadvantaged groups, such as migrant women, refugees, and internally displaced persons. It specifically ascribes a set of responsibilities to receiving countries in connection with migrant women's sexual and reproductive health. Among other things, receiving countries are required to put in place adequate legal remedies and accessible complaints mechanisms that can protect migrant women from discrimination and sex-based exploitation and abuse. They must also provide temporary shelters to migrant women who wish to leave abusive employers, husbands, or other relatives. As well, linguistically and culturally appropriate, gender-sensitive services must be made available to migrant women, including healthcare, emergency and social services for victims of abuse, and programs that are designed for those who are detained or isolated, right, such as migrant domestic workers. So that's what's we can discern from CEDAW's general recommendations. Receiving countries have similar obligations toward migrant children pursuant to the Convention on the Rights of the Child and the International Convention on the Protection of the Rights of all migrant workers and members of their families. Now, in the interest of time, I won't go into those in detail, but hopefully what I'm trying to paint here is a picture where there's a body of interpretation of existing international human rights treaties that guarantees access to sexual and reproductive information, goods, and services to migrants, sometimes to an equal extent, right, as to non-migrants. So what I would like to do in the remainder of my talk is to actually highlight for you a more recent development in international human rights law, namely the link between the right to life and the right to sexual and reproductive health. According to Article 6.1 of the International Covenant on Civil and Political Rights, or the ICCPR, every human being, this is what it says, right? Every human being has the inherent right to life. This right shall be protected by law, and no one shall be arbitrarily deprived of their life. Traditionally, the content of this right to life primarily concerned protecting people from extrajudicial killing in cases such as war, mass violence, and missing and disappeared persons. More and more, however, the interpretation of the right to life under international law has expanded in scope. And the right is now understood to also protect people's access to certain health care that is necessary for avoiding life-threatening consequences. Now, to be sure, the link between the right to life and the right to health is long recognized. For example, in the UN Human Rights Committee's first general comment on the subject of the right to life, and this is published back in 1982, it is acknowledged that it would be desirable for states parties to take all possible measures to reduce infant mortality and to increase life expectancy, especially in adopting measures to eliminate malnutrition and epidemics. Right, so the link between health and life is a long-standing one. I'm not disputing that. What I'm more interested in is trying to kind of flesh out the overlap between those two rights. As you can discern from the little quote I just provided you, beyond the passing reference of the reduction of infant mortality, right, the guarantee of the right to life as it was interpreted by the UN Human Rights Committee has historically played a limited role in furthering the protection of the rights to sexual and reproductive health. Indeed, as you know, in the context of abortion, the right to life of the unborn has frequently been asserted in opposition, right, to women's right to choose. Contrast that to the Human Rights Committee's General Comment number 36 that was published in 2019, so much more recent. In this latest interpretation of the right to life, the committee, in a number of places, explicitly highlighted the link between the right to life and sexual reproductive health. And by way of example, I'm just going to tell you a bit of what the court said on the issue of abortion. So the committee said relating to abortion. So it said that although states parties may adopt measures designed to regulate voluntary termination of pregnancy, those measures must not result in violation of the right to life of a pregnant woman or girl. Rather, state parties must provide safe, legal, and effective access to abortion where the life and health of the pregnant woman or girl is at risk, or where carrying a pregnancy to term would cause the pregnant woman or girl substantial pain or suffering. States parties should also effectively protect the lives of women and girls against the mental and physical health risks associated with unsafe abortion. In particular, they should ensure access for women and men, and especially girls and boys, to quality and evidence-based information and education on sexual and reproductive health, and to a wide range of affordable contraceptive methods, and to prevent the stigmatization of women and girls who seek abortion. And so you can see this is a much more elaborate and more explicitly acknowledged relationship, right, between the right to life and the right to sexual and reproductive health. And this, I argue, is new. And seeing as the right to life is guaranteed in relation to migrants and non-migrants alike, which is again confirmed by the Human Rights Committee in the same general comment, right, general comment number 36, this more expensive understanding of the right to life adds to the density of international law that protects migrants' right to sexual and reproductive health. In fact, returning to the case of Toussaint, and we see an instance where denying healthcare to migrants is held a violation of the right to life under international law. As mentioned, Neil Toussaint's court challenge against her exclusion from the IFHP actually found no success at the federal courts. And her subsequent request for leave to appeal to the Supreme Court of Canada was also denied. After exhausting domestic legal remedies, Neil lodged a complaint against Canada with the UN Human Rights Committee. Pursuant to the individual communications procedure set out in the optional protocol to the ICCPR, which Canada is a party. And in the summer of 2018, the Human Rights Committee issued its views in this case, finding Canada to have violated Neil's rights to life and equality. On the matter of right to life, the committee stressed that states parties are under an obligation to protect people from reasonably foreseeable life-threatening situations. And failing to do so can result in a violation of Article 6 of the ICCPR, even if such situations do not result in actual loss of life. This means that at a minimum, states parties like Canada have the obligation to provide access to existing healthcare services that are reasonably available and accessible when lack of access to healthcare would expose the person to a reasonably foreseeable risk that can result in the loss of life. And that's what the committee said. In relation to non-discrimination and equality, the committee opined that it is the general rule that the rights enumerated under the ICCPR are guaranteed without discrimination between citizens and aliens. States, therefore, cannot make a distinction for the purpose of respecting and protecting the right to life between regular and irregular migrants. Again, I'm quoting the committee. Now, in other words, when states parties use legal status, right, to delineate who is included in healthcare programs, and being excluded from those programs could result in a person's loss of life or irreversible negative health consequences. According to the committee, this line drawing is not reasonable and therefore constitutes discrimination under Article 26 of the ICCPR. As a result, Canada was ordered in this case to provide Neil Toussaint with adequate compensation for the harm that she suffered and to take steps to prevent similar rights violations from happening in the future, including undertaking necessary law reform to ensure irregular migrants have access to essential healthcare to prevent a reasonably foreseeable risk that can result in loss of life. So, to conclude, international human rights law undoubtedly, in my view, protects migrants' right to health, including their right to sexual and reproductive health. And this entails the extension of timely and appropriate information, goods, and services to migrants by receiving countries. it also requires receiving countries to create the necessary condition in society to foster migrants' sexual and reproductive health, right? Such as tackling migrants' legal and economic precariousness, right? Their social isolation, and xenophobia and racism, and gender inequality. And when governments fail to live up to these obligations, mechanisms do exist under international law to help migrants vindicate their rights, as seen in the case of Toussaint. Now, the challenge, of course, is how to effectively hold the governments who have violated international law to account, beyond simply just naming and shaming. This, unfortunately, is the challenge that Nell and her legal team are currently struggling with. For disclosure, I've been working as a co-counsel for one of the interveners that's involved in this case. And so if there is any interest in further discussion of this, I'd be more than happy to do that in the question and answer period. Otherwise, that concludes my remark today, and thank you very much.
Thank you so much for that incredible paper. I have a few comments, and then I also have some maybe questions and thoughts for things that I thought might be ideas for future research. So I thought I would talk about those as well. So I guess to start, the first thing is I really appreciate the way that you use the vignettes to kind of introduce the issues that are carried out in the article, and specifically to highlight these three kind of interrelated factors that come up again and again in the article, which is this increase of direct sexual and reproductive health risks, this greater likelihood of engaging in risky behaviors, and then this barriers that exist in accessing SRH goods and services. So the way that those three things are interrelated throughout the vignettes and how those are then carried throughout the paper, I thought is really, really well done. I then like how you turn to talk about this right to health and rights of vulnerable populations. And the paper in itself provides this beautiful overview of the ways that we have these international commitments to these two things in a way that we haven't really seen papers do before. And not only what these entail, but how these might apply. So when you then kind of tie them into the vignettes, you show us not only what the articulation of this right to health and of this rights of vulnerable populations is, but how they could potentially play out in the context of sexual and reproductive health and how those might be tied to the vignettes, which is really interesting. You then in the paper move us into rights to life and non-discrimination against migrants and tie us into these two other additional international obligations where we see recent examples like the Toussaint case and show us how those are then also potentially interlinked with this conversation about sexual and reproductive health when it comes to migrants. So a couple of questions that I had for you that maybe would spark discussion and that maybe others had, and some thoughts that I had about the paper as well, which I really, truly enjoyed. So I guess my first question has to do with the choice of the vignettes, why you chose to do this. I think it works really well, but the process of integrating those, why, for instance, MIA is based on a 2019 Columbia Supreme Court of Justice decision, and what sparked the other two vignettes that you lay out for us. I think because one of the questions that I have about the paper, and I think maybe this would be a future paper, is I'd love to see what the case law is in other countries and or how the Toussaint case ultimately will impact case law in Canada. That was kind of the question that I was left asking, and I think that, you know, is a paper in itself. The second question that I had is I really enjoyed this focus where you're focusing in on sexual and reproductive health, especially given that this is an area where we generally have a lack of research, a lack of funding, a lack of emphasis, and a lack of protection of women's sexual and reproductive health. So to use these 4 rights that you spell out in the paper and then to zone in specifically on that area, I think is a really important choice. And wondered if you would consider kind of interrelating it to the existing body of research that looks at this lack of funding, lack of emphasis, in order to kind of emphasize that this is in fact part of a bigger problem. Another question in relation to that, so obviously the focus of the paper is on cisgender women, and you talked in your conversation about the LGBT community, and I'm interested in thinking about how these rights that you've talked about throughout the paper, how they would apply to non-cisgender women. And especially in the context of the rights of vulnerable populations, because that right very much emphasizes woman and man within the specific text of the obligation. Another question that I had for you that it sounds like you're already considering as a potential future paper is just a comment further on what's going on with the Toussaint case, also what's going on in light of the Ontario Superior Court case that's being pursued for damages. So telling us more about what the subsequent journey of that case is after the Federal Court of Appeal and UN Human Rights Committee decisions have come out. A couple other things. So specifically in relation to the Toussaint versus Canada case, and I thought this before, and then as you discussed it more, it kind of percolated a bit more in my mind. So this idea that now we have the UN Human Rights Committee finding, which basically emphasizes that in order to fulfill this right to life and in order to fulfill this right to equal protection of the law, that there needs to be healthcare access when there is this risk of life, and that there's this potential problematic differentiation that's being taken with the IFHP. So I'm interested to learn more about how that would actually play out in case law and how there might or might not be examples down the road. I think especially given this conversation about the fact that the federal court does not necessarily take seriously these international obligations, what then is the significance of this going to be? Is there going to be any impact on Canadian law? So to think about what the impact for specific scenarios in Canada might be there. I think the last thing that I just wanted to point out was I liked the way that you drew COVID-19 into the article of it. Obviously, COVID-19 has had a huge impact on sexual and reproductive health. We've seen it on impact to access to abortion generally, access to fertility services, and support during pregnancy and birth. We've also seen it in the context of studies that were done here in Toronto of migrants who are unwilling to get their COVID-19 vaccines because of fear of having to present identity documents in order to do that. So just encouraging you to pursue that further as you do in the article, because I think there's an interesting question there in terms of how that's going to directly and continue to affect sexual and reproductive health. So those are all the comments that I had, and I just wanted to say thank you again for the opportunity to review this paper because I really, truly enjoyed it.
Right, the two of you to sit in the front.
Yeah.
Yeah. So I'll bring a chair. And I'll open it up for questions. So thank you very much for a very interesting presentation and commentary. I'll start, as I said, with some questions from students. So if I can ask Lauren, if you can ask your question.
Sure, thank you. Thank you both for the presentation. I'm wondering if there are states that serve as models for best practices in providing migrants with sexual and reproductive health care. And if so, the policies that they've adopted.
I'll leave that one to you. I actually had the same question about whether there's specific examples of where these international obligations have been really successfully applied.
So I'm gonna take a sip of water for when it comes to migrant health, generally speaking, my impression is that it's not a very rosy story. So unfortunately, many countries. So we need to look at countries that are considered more high income versus countries that are perhaps lower middle income countries. Now, in high income countries, I'm not aware of any one jurisdiction that have essentially where there's virtually no barriers to access to healthcare. Right? There are some jurisdictions in Europe, for example, that actually do allow migrants, or legally speaking, migrants have entitlement to public funded healthcare. So these might include countries like Spain, Portugal, and to some extent Netherlands. So there are countries like that, but the more I learn about those countries is that despite what the law actually says, there are a lot of barriers that actually play out on the ground when people accessing services, including sexual and reproductive health services. So things might include that you need to again show some kind of a residency document. Right? It doesn't mean that you need to have some kind of a visa, but they require you to show that you're a resident here, and that is difficult to produce for a lot of people. So there are that kind of administrative hurdles that then serve as kind of what we call street level bureaucracy, kind of a deterrent. So unfortunately, in the kind of internationally speaking, among the high income countries, I can't think of anyone that I would kind of point to and say, well, this is that's what we should model after. But of course, to the extent that there are countries that do have at least legally a provision for migrants' entitlement to public funded healthcare, I think that is a great start. Now, in terms of lower middle income countries, I think the situation there is often it's harder because we're talking about resource issues, right? Oftentimes, the healthcare system of the receiving countries themselves are not robust enough to even provide many of the sexual reproductive health services to locals. Then the fact that some migrants are now coming in to sometimes access some of these services because they require that is sometimes seen by the locals as competing for the same pie, and that actually creates a resentment and sometimes xenophobia. So I think it's there are multiple jurisdictions that are trying, but I won't be able to come up with one kind of this unicorn that we can point to and say, let's just model everything after them.
Emily Heen.
Yeah.
Maybe one of your questions.
Yeah.
There's one that is already answered.
Yeah, exactly. Sorry, let me just pull up my questions. I guess one of my questions was, you kind of touched on in the paper that like sometimes people are refused for like, not necessarily like the law saying that migrants can't be helped, but people can be turned away for things like language barriers. And I was wondering if like, are there laws which can ensure that that doesn't happen? And if so, would those even help, or are they kind of like an excuse for turning migrants away in terms of saying, well, we don't have access to a translator, so I can't help you?
Well, I think there's certainly an argument to be made that our law currently is capable of mandating some kind of interpretation services. I don't think that we're taking great advantage of it. Right? I think the jurists in general, including the courts. Right, so I mean, as many of you know about the Eldridge case that talked about the provision of sign language interpretation. But the court in that same case also very clearly states that, you know, whatever reasoning that it says in that case doesn't apply to provision of language, interpretation of based on second language. So, you know, again, I take a different view on those kind of things when it comes to whether it's an equality claim under the charter or a human rights claim. I think that our existing instrument is there if we want to use it to challenge the fact that the non-provision of communication is a form of discrimination.
Thank you.
Yinzi,
My question is as for illegal immigrants, they may not seek SRH care for help since they may be afraid of to be deported. How can government deal with such a condition and encourage them to SRH care?
So, yeah, I mean, I think that's a tough issue because, you know, again, speaking from, like, if you're asking what the government could or could not do, I think oftentimes the fear is that the fact that the government is involved actually deter people from accessing services. This is because of the concern that by accessing services that they may expose, that may risk exposure and detection by the law enforcement, and therefore they might be removed from the country down the road as a result of that. And just, you know, because this, I think, touches on, Katie, your point earlier about things that's happening with COVID-19 and access to vaccines. We know that early on in Ontario, for example, there was a practice that the Ontario government introduced that decides to share all the COVID-19 positive cases kind of information with the law enforcement, right? With the first responders, including the law enforcement. And that, it was, I think, rightly criticized by many people because, you know, that kind of very personal medical information, by sharing that with the law enforcement, there's no telling what the law enforcement will do with that. And I think it actually generated some fear among the people without status or irregular migrants to actually, I mean, it creates a deterrent, right? Why would anybody now want to get tested if they know that their information, if they test positive, is going to be shared with you know, the first responders? But obviously, you know, quickly, the Ontario government just backtracked on that. But yeah, so I think that, you know, perhaps just reframe some of your question a little bit. Maybe that, what are some of the things that the government perhaps needs to do sometimes to kind of shield itself, right? So that, you know, from the actual healthcare service access experience of the undocumented migrants. That might be the right question.
if I can add to that, it's a concern also in terms of trying to use legal resources to get redress, or if something bad happens. And so in the health law class that I teach, we discussed, among other things, the organization of clinical trials. So there has been a time, but it's actually still continuing in the south of the United States, particularly where people who are illegal immigrants are included in clinical trials because it's for them at least some chance of having some level of healthcare. And when something bad happens, they will be in a very difficult position to try to obtain legal redress or to go to the court. So it's a general big issue for healthcare related concerns of people in a precarious situation.
Yeah, for sure. And I mean, I think that was actually acknowledged by Justice Zing in the first instance of the federal court, right? The judge actually says he had no idea why the government is not deporting Toussaint, right? Like, just doesn't understand that. And presumably that would have solved all the issues. But obviously in a very draconian way. But I think what, to me anyway, that underscores is that it actually takes a lot of bravery on the part of Toussaint to actually bring the case forward, right? Risking the potential of removal from the country.
Vita,
Which one? Which question?
I would say choose whatever one you find most interesting.
Okay, I think that I had a question about language rights that I think has been addressed. So maybe I'll ask a question that's a little bit outside the scope of your paper, but talking about kind of Canada's obligations in the international forum. And in my research, I found like the Canada 10-year global health and policy plan, including a focus on women's rights and reproductive rights and sexual health. And I was just curious if you were aware of any tangible and meaningful steps from Canada in the international forum under these obligations outside of our borders, under this very it's a big obligation that they've committed to, and it's a lot of money. And I wasn't able to find anything other than just kind of pure dollar signs without any actual kind of initiatives behind it. So that was maybe my, or just curiosity question.
That I trust there are people with the kind of not, you probably know more about on that front, right, in terms of what Canada is or is not doing internationally in terms of fostering sexual and reproductive healthcare health generally. In terms of like my take on this, which is more from the migrants' perspective, I'm not aware that the government is addressing this issue. I mean, if the Canadian government is not willing to provide healthcare to its migrants within its own territory, I doubt very much that it's trying to push that agenda globally. But that's my own take. I'm not aware of specific initiatives.
Okay. Mina.
So I had a question kind of about the practical right of access. So even though there's recognition in these international conventions about the right to access sexual and reproductive health care, I think there's really significant barriers that still exist to enforcing this right. And so just looking at the Toussaint case, like there wasn't any favorable decision in the domestic courts. And I think going to a domestic court is in itself like really arduous on the individual, and then to have to go to the Human Rights Committee, it just seems like a really impractical way for a lot of people to try and enforce that right. So I was wondering if you could speak to maybe any additional steps that you thought would be necessary so that like international rights are actually effectively operationalized.
That's a great question, and I think that touches on a number of things. One is, if we don't want to resort to the courts, right? I think there certainly needs to be a further penetration of these international human rights norms domestically, such that it's embodied in our professional responsibilities. For example, I'm a part of the service providers, or that perhaps even at the municipal or provincial level, there's governmentality of things, to think about how in the provision of healthcare can we be more inclusive of migrants, right? Without having to wait for people to challenge the non-inclusion. Right? So yes, I mean there's definitely things that could be done ahead of time. And that's certainly what we would like to encourage the government and everyone that's involved in this space to do, right? So that's the first point I will make. But the second point I'll make about that, and which relates to Katie, your question about what's the aftermath, right? About Toussaint, because that speaks to, well, I think court still plays a role, right? If we can nudge the government to do something, and that speaks to the ongoing case now before the Ontario court to try to implement the view from the UN Human Rights Committee. I see that James is here, who is part of Toussaint's team. So I'm actually going to let you, if you don't mind, you can also speak to that. But again, I'm coming from somebody who's representing one of the interveners. Our position is that essentially, let me kind of backtrack a little bit in terms of what the government decided to do, right? In the wake of the Human Rights Committee's decision in 2018, is that after some back and forth letter writing between Toussaint's team and the government, in February 2019, the federal government actually comes out and say that they're not going to really do anything because they disagree with the Human Rights Committee's interpretation of Canada's obligation under the ICCPR. So essentially saying that it's rehashing everything that it said before the Human Rights Committee and said, well, for those reasons, we're not going to do anything, right? And to us, right, the interveners that we present, to us, that decision-making doesn't comport with this principle of pacta sunt servanda, which is Latin for promise must be kept. So this is a well-established principle in international law, and it manifests itself, for example, in Article 26 of the Vienna Convention of the Law on Treaties. It actually says that every treaty in force is binding upon the parties to that treaty, and also they must be performed in good faith, right? And our argument is that the way that the government is responding to the Human Rights Committee is not good faith, right? You cannot simply reassert everything that you said before and say, well, I just disagree, so we're not going to do anything. And that is not a good faith response to a Human Rights Committee that has found your previous argument to be wrong. And there's also a body of case law domestically here in Canada that says any kind of use coercion, so these are preemptive norms under international law, is prima facie considered principles of fundamental justice under Section 7. So we're arguing that pacta sunt servanda is one of those use coercions, and therefore it's principles of fundamental justice under Section 7. So then you can see that to the extent that the government's refusal continues to threaten migrants, including non-status migrants' right to life and security of person, and to the extent that the refusal to implement that view also is not comport with that pacta sunt servanda principle, also that there is a strong argument to be made under Section 7. So that's essentially our position and what we're trying to advocate.
Anything to add? No. Okay. If anybody else has a question, please do so. But I'll first go to Jane, and then I'll.
Okay. I guess my first question was answered, so that's great. But my second question was, what I found was particularly interesting is this sort of trade-off problem that was highlighted in the I don't know if I'm touching the I know me, the video there. I think it's like what first came to mind for me was like, in theory, demanding employers to provide private health insurance to their migrant employees. It seems to, on the surface, like at least solve the access to health and service access issues. But it also was counterintuitive in a way. It results in a more heavy dependency and a power imbalance between the migrant employee and the employer, both from like a livelihood and a financial perspective, but also what you highlighted just in your presentation kind of came to mind of just the fear of the employer finding out that they have these sexual and reproductive health issues and the fear of employment termination. But I guess like my question is the position when it comes to these more practical solutions, is some coverage better than none at all? So in this way, is it better to have laws and policies that require employers to provide insurance plans, regardless of this, like the trade-off issues of heavy dependence and fear of prosecution?
I mean, certainly, I mean, if you need to make that trade-off, then I would certainly advocate in favor of the lesser evil, right? To at least have some coverage. But if you're asking my position, it would be that let's not do that trade-off at all, right? Like let's make sure that everyone truly have both a legal entitlement to healthcare and that that legal entitlement can actually translate into actual access. Now I should be clear about the fact that yes, as I've mentioned both in the paper and my presentation, that there's some problems inherent with the private health insurance alternative. Right? It is private health insurance, so the insurance company has a lot of say in terms of what it wants or what doesn't want to cover. But things are not that much better under the public side of things either, right? So we know that in Canada, going to the migrant worker example again, even when they do have access to public funded healthcare, many still can't or won't use that coverage. Right? They can't because sometimes we know that employers actually withheld those workers' health cards, so they won't be able to access healthcare unless they ask the employer for the cards. Sometimes they won't do that because again, for fear of not wanting to be seen as weak and therefore not being invited back next season to work. So yeah, so I think it's a multi-pronged problem that needs to be addressed at both the entitlement level and the access level. And hopefully there's not a trade-off, right? We need to address all of this all at once.
Question there in the back.
No, I think James, maybe it's just it's an opportunity.
He's the counsel on Toussaint.
Okay.
Thanks to Sandra.
I think I'm here to hear YY's wisdom.
Okay. Thank you for taking on this case. So Bernard had a question.
It's at international law and it wants to do sexual and reproductive health, but it could include the expression of a receiving country. What makes a country a receiving country? Would it be, for example, that an immigrant is given prior approval to come? Does it cover someone who was committed under a visa that has expired and there's no government action for deportation? Would it include someone who was here incidentally? For example, a migrant from an Asian country changing flights at Vancouver, Montreal, Toronto, with an overnight stay, so allowed into the country for the night. Leaving country, so as to be bound by international treaty obligation.
So that's a great question, and actually international treaties use different languages. Sometimes we use the country of destination. Sometimes they refer to transit countries. That's in my view could sometimes count as receiving, right? Because a lot of times people's stay in those transit countries become protracted, such that it is effectively living there for long term. Now, in terms of your question about who counts, I think to the extent that we're talking about migrants, at least for my purpose, and I think that's what most people working in this field would agree, is that we're not only counting the last scenario that you're talking about, where people simply transiting through a country overnight to for perhaps change of flight or certain things. The people's reason for being in a country truly has to be they want to settle in that country, and so for that reason, I think that also can be a response to some of the questions that were often asked about, well, what if you expand the rights to health so broadly to all migrants? What do you address the concern about health tourism, where for example, Americans can simply drive across the border to access healthcare. And my response is always that, well, but you won't count them as migrants in that context. Right? They're not migrants, they're not coming here to live. They're coming here for a short stay. So I think our law is capable of distinguishing between who is actually a migrant and therefore access to healthcare, and who is simply here for, and that's the language that's used in Canada Health Act, right? Who is simply a visitor, a transient, or a tourist. And so those are not counted. I won't count them as migrants. And just, I know that we're running out of time. I'll just quickly mention that here in Canada, our practice has actually been that some people, you know, if you're here, your visa has expired, but you know, let's say that you have put in a request to extend your visa, your work visa or study visa before the expiration, you have maintained status, and so long as you have maintained status, in theory, you should be able to access healthcare provincially. It's a very long and sometimes tedious process, so that doesn't always happen. But in theory, you should have coverage.
Okay, Rebecca.
I'd like to extend the conversation about Toussaint, especially given that we have the council here. What is the state of play now? You say it's before the Ontario court in terms of trying to apply the Human Rights Committee decision. Is that where we're at?
So yeah, so I'll make a few comments, and you know, James, if you want to add anything. So essentially, the attempt is to implement the Human Rights Committee's decision. So unfortunately, the Attorney General of Canada has thrown a bunch of procedural contestations at the team. Right? So some of those includes the fact that you know, there's concern about the case might have passed the statutory limitation period, that you know, some of the questions shouldn't go to the Ontario Superior Court, and should go to federal court. And initially there was also some concern about res judicata, because there was concern that we're adjudicating the previous federal court case. So essentially the federal government just throw the whole kitchen sink at the team and on the procedural front. And so in August, Justice Correll from the Ontario Superior Court actually issued a decision, essentially strike down every single one of those procedural attacks. And in that decision, the judge was, you can see that he was clearly not happy about what Canada is doing, and used some very colorful terms, right, calling the government's argument dog whistling and so forth. But unfortunately, the government, so the government has appealed that decision to the Ontario Court of Appeal, and as you know, that it's now going to move forward on the appeal, parts of Justice Perot's decision relating to jurisdiction and about statutory limitation. The court said that that's a decision from the lower court that can be appealed and reviewed by the appeal court. So that's where we're at. So unfortunately, a lot of maneuvering on the procedural front at this point. Hopefully we can clear that and actually get to the merit of the issue.
We're nearly at the end of time. So what I quickly look at some questions that may already have been answered, but maybe, and you can say if you feel that your question have been answered. So if maybe one after the other, Serena, Jasmine, and Monica can, I think the question was answered. And Emily Groper can just say briefly their question, and then we can see what you can respond to. Otherwise, at least you can note them down. Okay, so if you can just, in a short way, ask your question if you feel that your question hasn't been answered, and then you can see what you can respond to. Okay.
So as you mentioned in General Comment 36, the expanded right to life and the obligations for states to provide safe, legal, and effective access to abortion when continuation of pregnancy would bring mental pain or suffering. Given the increased risk of sexual assault faced by migrants, what obligations exist on a state where its own laws contradict with its duties under international human rights law. So I'm thinking of the United States with the recent trigger bans, making no exceptions for rape or incest.
And the next question. Yasmin, yeah,
Both of my questions were answered.
okay. And Emily,
Yeah, my question is a bit of a mouthful, so I'll let you answer Serena's question first, then if we have time, I can ask mine.
okay.
But I guess my response is relatively quick, which is, well, I think, the Toussaint case offered a model for, for anybody. Obviously, to get to that international level, they need to first exhaust domestic legal remedies, right, to get to the Human Rights Committee. But, once you get there, I think, the willingness that the Human Rights Committee has shown to kind of apply what it says in the General Comment number 36 to these kind of scenarios, I think it's hopeful, I think. And so maybe that would be a remedy.
The US didn't ratify.
That
It
was
didn't, right?
that was kind
Isn't
of
it
in the
one
back.
of the
Yeah,
countries that didn't, like it signed but didn't?
yeah, that's what I was kind of what I was wondering. So,
Okay.
Yeah, I'm not sure about that either. If they're,
I think my understanding, I could be wrong, is that they signed but did not ratify, so they're not bound by
Right.
commentary number 36.
Right.
Because I had,
But
No,
that's-
they've ratified.
They
They've
did,
ratified
okay, they
this
did.
year. Oh, yeah.
okay,
It's the ICESCR that they
Yeah.
signed and can ratify.
right, okay. Thank you.
Just, Trudeau, just a follow-up.
Mhm.
There's a very important Spanish Supreme Court decision applying the Spanish government refused to apply a CEDAW decision. You might know about this decision. It went to the Supreme Court of Spain, the apex court. I'm not sure that's the exact name. But they said that Spain has an obligation. It was a case, I think it was a violence against women case. But Spain specifically said, this court said, you have to apply the CEDAW decision. I don't know of any other decision, and I don't unfortunately know of much other research. The CEDAW commentary, the second edition of the CEDAW commentary is coming out, and some of the other chapters might have some of those decisions cited in.
No, I'm not aware of that, but thank you for flagging that, Rebecca. And part of the problem with trying to implement this here in Canada is obviously Canada's dualist approach to reception of international law. Right? I think that might be different in the Spanish context. So that might
That's
be
true. It might be
something that we need to watch out for. But I will look into that.
By CEDAW, I mean Committee on the Elimination of Discrimination Against Women. Sorry to be so acronym.
Emily, briefly, or
Sure, I can give it a go, and if you can answer, great. If not, we don't have time, it's okay. My question kind of flows from the Toussaint decision. I can't help but think that while, her exclusion from the IFHP was undoubtedly discriminatory and contrary to international conventions, the federal court kind of does raise warranted concerns with providing publicly funded healthcare to any undocumented migrant, specifically whether doing so kind of provides incentives for foreign nationals to illegally enter Canada to access healthcare. And if it does, it's particularly concerning given that, our healthcare system already has problems kind of servicing those individuals that already reside in Canada, Ms. Toussaint included. So my question then is, what is the solution to effectively balance the state's duty to protect life of both its legal citizens, but also incoming undocumented migrants? Like, is it the court then that's supposed to assess on a case-by-case basis the severity of the impact of the decision for that specific claimant? Or are there other policy concerns that kind of can effectively answer that tension?
And my very brief comment would be that, instead of trying to weigh those two concerns, is to say, if you look into the actual empirical studies that have done around this, there's very little evidence that shows people actually travel to get healthcare because they feel that this country is offering better healthcare than their home country. Most people travel because they have existing ties, like family ties, or for job opportunity. And in fact, in the Canadian Doctor for Refugee Care case that concerns the cuts to individual health In that case, one of the argument brought by the government was that, well, the reason why we're cutting this is because we don't want to attract health tourists. And in that case, the court actually invited the government to provide any kind of evidence that it has. The government has nothing. And so just on that, I would just kind of push back a little bit on that point and just say that I don't think that it's a valid kind of weighing of those two concerns. I think sometimes we might exaggerate the concern of so-called health tourism.
On that note, please join me in thanking the presenter and the commentator on a very interesting, and also I thank the audience for a very interesting discussion.